If, as the Declaration of Independence asserts, all men are indeed created equal, clearly the new government formed under the Constitution did not see slaves as men. So how did the states view the legal status of slaves prior to emancipation? Some of the answers are horrifying. Prior to the Civil War, many states categorized slaves as chattel under the law. Chattel, much like the word cattle, refers to the ownership of domestic animals as personal property. It's easy to understand how the hatred and cruelty of chattel slavery was one of the major factors that contributed to the dehumanization of slaves and, subsequently, all African Americans. Many slave owners and their supporters believed that Black people were somehow less than human, and therefore the argument that it is wrong for one human to own another doesn't apply using this line of reasoning. It's easier to sleep at night believing that the slaves that you keep are legally classified as domestic animals rather than fellow human beings of a different race who happen to have a noticeably different color of skin than their own. The legal, physiological, social, and psychological association of slavery to livestock, as absurd as it is, still lingers within a deeply rooted prejudice against Black people in America. Article 1, Section 9 of the Constitution states that Congress was not allowed to prohibit the overseas importation of slaves prior to 1808. This meant that Americans had been guaranteed at least another 30 years to legally purchase imported slaves at the time the Constitution was written. In anticipation of this limitation, Congress passed an act to prohibit the importation of slaves in any port or place within the jurisdiction of the United States in March of 1807, and it took effect the very first day allowed by law, which was January 1st, 1808. So why the sudden change of heart during a time when owning and trading slaves within the United States was so very lucrative? Well, the new law only prohibited the importation of slaves from other countries. It did not prohibit the trading and owning of slaves within the states. Don't get me wrong, there was still some smuggling of illegally imported slaves into the states after 1808. But the massive influx had stopped. But while the imported market all but ceased, a whole new era of slave trade began in the States. Without serious competition from overseas traders, the American slave market boomed like never before. Slaves were bought, sold, and transported. While their captors enjoyed the benefit of horsepower, slaves were transported by foot, often chained to one another by the neck, over hundreds of miles, to be delivered to a new master wherever he may be. And the slave trade wasn't a delivery-only business either. It was much more in your face than that. Traders even had storefronts throughout the South where you could ride into downtown Atlanta and maybe buy some tobacco and lamp oil at these fine establishments before you mosey next door to browse the human inventory at the slave auction. At this long-established storefront in Alexandria, Virginia, slaves were packed into these holding cells until someone purchased them. At Price, Birch and Company, there was really no need to even wait for an auction. You could just go in there and peruse the merchandise just as you would at the general store. And so slavery continued to expand greatly in America until the Civil War began in 1860. The slave population grew the natural way throughout the 1800s as slave owners encouraged procreation between male and female slaves. Sometimes this happened through slave marriages permitted by their owners. Sometimes it was consensual. Sometimes it was not. Sometimes these births were a result of arrangements that were made between owners of two slaves that were thought to be more capable of producing slave children with preferred physical traits. Because when two slaves had a child, that child was not considered to be theirs. That child was considered to be property of the owners. Often, children were born into slavery because their mother had been raped. Prior to emancipation, the Constitution protected slavery and made equality, as we know it today anyway, impossible to achieve. 3 years before the war started, in the infamous 1857 case Dred Scott v. Sandford, the Supreme Court held that slaves and their descendants, even freed descendants, were not citizens of the United States and therefore were not entitled to the same rights and privileges entitled to a citizen. Numerous legal scholars have considered the Dred Scott decision to be one of the worst ever made by the court. The period of Reconstruction immediately following the end of the Civil War, between 1865 and 1875, produced 3 fundamental civil rights amendments to the Constitution, fortified by several federal civil rights laws. In 1865, the 13th Amendment brought an end to legal slavery in the United States. But what did that mean exactly? What was the precise legal status of newly freed slaves at this time? Did freedom from slavery come with citizenship? Or would the Dred Scott decision somehow follow slaves into emancipation? Would the new laws and amendments apply the same to freed slaves as to everyone else? How would congressional apportionment be affected by a population of millions of slaves suddenly being counted as whole people instead of only 3/5 of a person? Did freedom come with voting rights? Did it come with any rights at all beyond the prohibition of human ownership? When slaves learned of their new freedom, what did they do? Where did they go? And what did they experience along the way? Many freed slaves tirelessly sought out family members who had been separated from them during the continual buying and selling cycle of the slave trade. After gaining his freedom, one determined Georgia man walked 600 miles to be reunited with his wife and children. It became common practice for the newly freed to place ads in newspapers that sought information regarding displaced loved ones. Precious few were reunited. While the first few years following the passage of the 13th Amendment had its share of obstacles, they stand out as a sort of honeymoon phase of the Reconstruction period. These were the years in which the newly freed enjoyed several notable achievements. They took advantage of new educational opportunities, whether through self-education or through one of the many black schools and colleges being established in the South. Beginning in 1965 with Shaw University in South Carolina, and continuing with schools like Fisk University in Tennessee in 1866, and Howard University in Washington, D.C. in 1867, which are just a few examples. But learning to read or pursuing a college education could only do so much for a former slave without full citizenship, equal protection of the laws, proper due process, full participation in the political process, and the right to vote. On March 3, 1865, months before the 13th Amendment was even ratified, Congress passed an act to establish a bureau for the relief of freedmen and refugees, to provide food, shelter, clothing, schools, settle disputes between whites and blacks, and several other essential services to newly freed African Americans in the South. But the Bureau was severely underfunded from the start. It only had enough money to hire 1,000 agents to serve the entire South. Still, these agents were able to establish over 4,000 black schools that served nearly 300,000 students. During its first few years, the Bureau converted old Confederate military hospitals into previously non-existent healthcare facilities for African Americans in the South. In May 1865, while Congress was out of session, President Johnson ditched the plans that looked out for the interests of freed people and instead pandered to white Confederate landowners. Landowners from whom the government had seized portions of land at the end of the war. Land that was intended to be divided into 40-acre parcels and distributed to freedmen as promised. But Johnson prevented the Freedmen's Bureau when it came time to distribute the land to the freedmen. Instead, he returned the seized Southern land to its former white owners and offered pardons to former Confederates who agreed to take an oath of allegiance to the United States. Johnson appointed provisional governments in the South, and only whites were allowed to vote. Imagine the fear of former Southern slaves when those elections placed former leaders of the Confederacy into the new provisional governments of the South. And just as Johnson's opposition feared, these provisional governments passed the Black Codes, which were a series of laws that attempted to roll back the recent freedoms gained by African Americans, denying certain types of civic participation like the right to serve on juries, to testify against whites, to serve in state militias, to own property or firearms, to hold certain occupations, to purchase alcohol, and, of course, the right to vote. In some places, black people were simply not allowed to be unemployed. Unfair labor contracts forced black people and their children into work that wasn't much different than indentured servitude or slavery. It wasn't long after the 13th Amendment abolished slavery that it didn't seem quite so abolished anymore. And 1865 wasn't even over yet. This is one of many reasons why most freed people in the South remained poor and without property of their own during Reconstruction. This meant that most freed people had no alternative but to work on white-owned plantations, often for their former masters, for next to nothing. Freed people complained of owners who never told them they had been emancipated, or who had just plain refused to release them. No matter their efforts after emancipation, the most common type of work that freed people performed was known as sharecropping. Here's how it worked. Families were allowed to rent a portion of a plantation in return for around half of the profit. This forced sharecroppers into a continual cycle of debt that was impossible to escape. The new Southern state government's so-called Black Codes were so cruel and unfair that Northern Republicans immediately took action to oppose them. Some wanted to break up Johnson's loyal state governments, remove all former Confederate leaders from office, and demand that black men in the South be guaranteed the right to vote. So they put all of these demands into what became the Civil Rights Act of 1866. This radical piece of legislation defined all persons born in the United States as citizens, specified the rights that they should be given regardless of race, got rid of the black codes, and prohibited states from denying citizens the right to protect property, make contracts with others, or bring lawsuits against others. It did not, however, grant black men the right to vote. The bill passed in Congress, but an infuriated President Johnson vetoed it. Even so, the House and the Senate had the votes necessary to override Johnson's veto, and the Civil Rights Act was passed in April 1866. With all this new momentum in Congress, the 14th Amendment was passed in 1868, solidifying the contents of the Civil Rights Act and creating a foundation for civil rights in America. So it's no wonder that the 14th Amendment is so commonly invoked in civil rights cases that go before the Supreme Court. The 14th Amendment says that all persons born or naturalized in the United States are citizens, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And notice that it says that all persons, not just all citizens, have a right to due process of the law, as well as equal protection under the law. Due process of law is the legal process of a fair trial and all that it entails. Equal protection under the law means that any and all protection provided by federal laws applies equally to everyone within the jurisdiction of the United States, and this protection cannot be limited or denied to anyone, citizen or not, regardless of race. The 14th Amendment is basically saying that it's not enough to just make a bunch of cool laws intended to make life better for people, but that those laws must apply to everyone. Despite Johnson's objections, Congress passed the Reconstruction Act in March of 1867, temporarily dividing the South into 5 distinct military districts, which eliminated the Confederate-led state governments formed by President Johnson. New elections were held in which black men had the right to vote for who they wanted to represent them in these new state governments. After an unsuccessful attempt to impeach Andrew Johnson the year before, the very general who led Union armies into victory, Ulysses S. Grant, was elected the 18th President of the United States in 1868. Republicans in Congress utilized the momentum of Grant's election win to push through one last constitutional amendment. And so on February 3rd, 1870, the 15th Amendment was ratified, guaranteeing men the right to vote, regardless of race. Finally, African American men were free citizens with the right to vote, participate in politics, and run for office. The same year the 15th Amendment was passed, the Enforcement Act of 1870 established criminal penalties for suppressing the right to vote as protected by the 15th Amendment. The majority of African Americans registered to vote in the following elections. Many ran for office, and many were elected into various public offices. Although most legislative seats in the southern states were still filled by white men throughout Reconstruction, about 2/3 8,000 African Americans held various state-level elected offices. 14 African Americans were elected to the U.S. House of Representatives, and 2 African Americans served as United States Senators, both from the state of Mississippi. A second Civil Rights Act in 1875 granted full and equal access to theaters, public entertainment, amusement, and accommodations. It also established penalties for violators. Now, if you didn't already know how this story turns out, you might be thinking that things are looking pretty good for civil rights at the end of the Reconstruction period. I mean, we not only had these 3 great new amendments, but we had actual legislation passed to create federal laws reflecting the intentions of the new amendments. Legislation that provided funding and established criminal penalties for violators. What could possibly go wrong? As Reconstruction blazed a trail of civil rights in Congress, it fueled racism and resentment by many whites in the South. The Southern Democratic Party bosses and bitter former Confederate leaders did everything in their power to oppose the new biracial governments that had been put in charge of the Southern states. Southern Democrats denounced every effort at Republican Reconstruction, claiming corruption among the Republicans, complaining about the rising taxes needed to pay for new black schools and other black services, for the very same black people who, for over a century, under the crack of a whip, without payment of any kind, worked the soil that produced the crops that made the South prosper. Former slave owners, once addressed as master, even if only by one slave, felt their entire God-given identity was stolen by those whom they considered to be biologically inferior or less than human. Feelings of white rage and resentment gave rise to organized violence throughout the South during the second half of Reconstruction. Northern and Southern Democrats alike established fraternities and secret societies, like the Ku Klux Klan, to oppose, intimidate, and lynch blacks and Republicans. The KKK wasn't just successful at violence and intimidation in the South. They were also incredibly effective at intimidating the Republicans up north. President Grant himself seemed to heed the Klan's threat to increase violence if Reconstruction efforts continued. In an effort to put an end to the violence, the Civil Rights Act of 1872, also known as the Anti-KKK Act, criminalized the use of law or custom to take away an individual's rights, privileges, and immunities set forth in the Constitution or federal law. Yet after so many years of trying to repair a divided Union, the North's commitment to Reconstruction began to cool. This allowed the Democrats to take control of the House of Representatives in the elections of 1874, and they came pretty close to winning the presidency in 1876 as well. The election of 1876 was so legitimately close that a long debate to determine the winner was inevitable. So, in order to avoid the long debate, the two parties came up with a compromise. The Republicans' candidate, Rutherford B. Hayes, would become the 19th President of the United States. But it would cost the battle over Reconstruction. In an agreement known as the Compromise of 1877, the Republicans agreed to let the Democratic Party have control of the South without any further efforts of Reconstruction. So after all this stuff happened, the Civil War and the achievements of the entire period of Reconstruction, seemingly overnight, the North became rather practiced in the art of looking the other way. And so the period of Reconstruction came to a close, and the Jim Crow era began.